I'm here with Stacey Serrato Mello from Hoy and Duane. Stacey is an attorney, and even just in our conversation here, I'm just learning so much. Just this wealth of knowledge. But I have people who come to me wanting to buy a house, right? So there's always those awkward conversations of, okay, who else should be on the mortgage with me? One thing I do explain to people is that just because you're not on the mortgage doesn't mean you can't be on the title. So you can still own a home without being on the actual mortgage note. But in that, then they have a few questions about, okay, how do we manage title? What if something happens, if they're dating somebody, or even if, they're married, or if it's just in a familial situation where it's brother, sister. What does it look like if one of us passes away? What does it look like if things don't work out, even in this relationship? So what would you say to someone, or how would you advise on the options of how to own a home?
So if you're a husband and wife, you would hold title as husband and wife tenants by the entirety.
Okay.
And that's a form of joint ownership. So if the husband passes away, his interest in the property would automatically go to the wife. No
Okay.
probates needed. And
Easy.
that's exactly. And it's vice versa. What you would do if you wanted to sell the property, if your spouse passed away, is you would file a death certificate and an affidavit that you don't owe estate taxes.
Okay.
And then you'd be able to sell your home. You don't have to probate the spouse's share. If you're an unmarried couple or boyfriend, girlfriend, or family members, there's two options. You could be a joint tenant with rights of survivorship,
Okay.
or a tenant in common. So the joint tenant with rights of survivorship just means that. So if someone passes away, that person's interest goes to the survivor automatically, just like a tenant by the entirety. So you don't have to probate the deceased person's share. Again, you would file a death certificate if you wanted to sell, and a estate tax affidavit. As far as tenants in common, what happens with that is if an owner passes away, you have to probate that person's interest. Let's say somebody has children and you pass away and you probate your part of the house, it would go to your heirs. It wouldn't go to the other owner.
Okay.
So what I would advise anybody who owns a home is to have a will, because if you're a tenant in common and you
Especially
pass
if there's
away,
kids involved.
exactly, you want to make sure if your estate gets probated that you're directing the probate and that interest in your house is going to the people you want it to go to. And if you have a will, that's really the only way you're going to be able to, to have that done. Even if you're a joint tenant with rights of survivorship, once you own a house, you should still have a will. And the reason is that the last person, the survivor, at some point may pass. And then if the person passes, there's no ownership interest left in that deed. So now the heirs will have to come in and they'll have to probate because there's nobody on the deed left. So you want to make sure you have a will in every situation.
And that probate's not fun.
Probate's not fun. It's expensive. It takes a long time. And so I always give people the option, if they're not married, I set out the two types of ways they can hold title, explain it to them, and I let them make the decision how they want to do it, because every situation is different. And then again, go back to saying, if you're a homeowner, you really should have a will.
Oh, that's great. Because I have people in different situations who are maybe now are thinking, okay, I am married, but what happens if we're not going to stay married?
Right. So in a divorce situation, the court automatically freezes all of your assets. So you can't go out and, go sell your portion of the home or do it behind your husband's back.
Right.
Even refinancing, they want to make sure that everybody knows, because you're taking out equity. A lot of times you can't just take out your equity and, say to the other person, sorry, I pocketed, the money. So in a divorce situation, it's going to be, monitored by the court and your attorneys, and just to make sure that the assets are distributed in the way they should be, because you're winding your marriage down. And
and what if one of the people in the marriage is not on the title?
So here's the thing. It's still, if you bought it during the marriage, still a marital asset. It doesn't matter. I get this question all the time. And people think, well, it's his house or it's her house.
Yeah.
And you're married. You bought it during the marriage. You probably live in the same house.
Yeah, right.
So it's a marital asset.
Yeah.
And going back
Okay.
to your point is that you don't have to be a borrower
Yeah.
to be on title. Yeah.
Okay. Yeah, no, that's great information, because I mean, I even get confused when I'm seeing the different ways that you can hold title. Like there's so many different things, and they all kind of sound a little bit similar. So obviously, if you're in a situation where you're trying to figure out how to hold title, if there are other people involved even in the transaction, just ask an attorney.
Yes.
I mean, this is
It's great
helpful for
advice.
me to understand, but definitely recommend, if anyone is getting ready to buy, I will absolutely wholeheartedly recommend Stacy. And thank you so much.
You're welcome.
Hey.